Hello, everyone. Welcome to this Goldsmith Chambers webinar from the immigration team. Today, it's me, Bronwen Jones. I'm a barrister jointly practicing in family, children law and immigration. And my colleague Sangeetha Iengar, who has a human rights focused immigration practice. She's done lots of international human rights work as well, primarily but not entirely focused on migrant rights. At the moment, perhaps most prominently, she is the director of the board for Phoenix, a charity working with migrants on the Greek island of Lesbos. And today we're doing a webinar and the second part to the coronavirus and hostile environment policy topic that was begun by Samina Iqbal and Sarah Pinder some weeks ago. And we're going to take you through some of the developments in the hostile environment related policy in the UK that have happened in some cases directly because of the coronavirus or related to it, but in some cases, and in particular the fee waiver policy, which I'll be talking about, as actually it's happened within this time frame, but probably not directly related to coronavirus, but it's related to this time. And so what has been the general development over the past couple of months in relation to the hostile environment. So I'm going to hand you over to begin with to Sangeetha. And just a reminder before we begin, please, if you have any questions, we'll deal with those at the end. We'll have a question and answer session at the end. Please, could you put them in the question and answer section of the broadcast? So there's one that's chat and one that's Q&A. So could you put them in the Q&A section, please? Over to Sangeetha.
Thank you, Bronwen. So yes, we're bringing this webinar in the context of racial injustice and discrimination, which has been brought into sharp focus in recent weeks. We're looking at two powerful components of the hostile environment that both center around forced destitution. So firstly, a quick run through of the genesis of hostility. Under Section 24 of the Immigration Act 1971, and you'll see in these slides that there are hyperlinks. The slides will be available online. They'll also be emailed to participants, and all of these hyperlinks will be available for you in those slides. Now, Section 24 of the Immigration Act 71 criminalized being knowingly unlawfully present in the UK, illegal entry, and breaches of conditions of a visa. So they were already criminal offences from the inception of that act. In addition to this, then Home Secretary Theresa May famously now declared that she wanted to create a really hostile environment for irregular migrants in 2012. There's a link to that infamous interview there, to solve what she deemed the problem of illegal immigration. And so in 2012, the Hostile Environment Working Group was set up, an internal working group banded together under the coalition government. And that group colluded to create a set of legislative and policy measures designed to make remaining in the UK without leave as intolerable and insufferable as possible. And so what was created was a labyrinthine maze of immigration controls that became embedded and are now embedded in our public services and in our communities in order to force people to voluntarily leave the UK, as oxymoronic as it sounds. And it was hoped that that would deter irregular migration flows into the UK. It has not. Voluntary departures have decreased in number since the inception of the hostile environment. It's had a rebranding through government from 2017. The Secretary of State has refamed this the compliant environment, but it's still very much defined by its characteristics of hostility. And those measures include limiting access to housing, to healthcare, to the labour market, and to opening bank accounts. The Immigration Act 2014 was the first brought in the first sort of significant wave of hostile environment measures. And they were then very quickly bolstered and expanded upon by the Immigration Act 2016. Now, I've divided this enormous labyrinth quite crudely into two forms of measures that I call overt and covert forms of hostility. But that is definitely an oversimplification of an enormous and heavily entrenched system, but all aiming to be punitive and painful, and further criminalizing from that 71 Act and isolating migrants. So overt hostility through primary legislation, so through those two instruments, the 2014 and 2016 Act, has essentially brought a method of social policing where state enforcement has effectively been devolved into individuals, our community, and our public services. So employers, landlords, education providers, healthcare providers are the new first guard of immigration enforcement. One example of this escalation in hostility and entrenchment of hostility is access to housing and the right to rent check. So the 2014 Act introduced the right to rent check, imposing civil sanctions on landlords who failed to check the immigration status of potential tenants. Going further than that, the 2016 Act went to criminalize landlords and agents for renting property without leave or having reasonable cause to believe that the person has no leave. So it criminalizes and goes much further than the first initial step within 2 years, and also introduced an accelerated eviction process. In practice, what this means is that it's encouraging landlords, individuals, to be overly cautious in renting to those perceived to be foreign, so perceived not to have the right to rent, which has obvious implications for discrimination on grounds of colour, on grounds of how they appear, their name, their manner, and forces those migrants into overpriced, unsafe, and unsuitable accommodation. The recent report, the Independent Chief Inspector of Borders and Immigration 2018 report, and again, that's a live link, has said in Parliament that the scheme is yet to demonstrate its worth as a tool to encourage immigration compliance. And yet we have seen escalations in that entrenchment of hostility. Now, very quickly, covert forms of hostility. So aside from primary legislation, these hostile measures have been brought in through institutional arrangements, policies, and bilateral MOUs, memorandums of understanding. Institutional arrangements, Operation Nexus, became very well known to us a few years ago. It was an institutional arrangement between the Home Office and the police, where suspected immigration offenders were referred by the police to the Home Office on site, rather than being arrested and prosecuted. The standard of proof of removal obviously being lower than the standard of proof to convict, and this enabling, as far as the government is concerned, a much cheaper and faster process for removal. More concerning perhaps now as we live through this pandemic are the covert hostilities that are being enacted through policies and bilateral MOUs specific to data sharing. There was data sharing that came to light between the Home Office and homelessness charities, where homeless migrants by the likes of St Mungo's and venerable organisations were being reported to the Home Office and their location being reported, so that again they could be quickly and cheaply removed rather than going through the welfare system that is there for them. And now the memorandum of understanding that has enabled data sharing between the NHS and the Home Office, which began as long ago as January 2017, still has its feelings felt. So the MOU enabled the NHS trusts to share information, personal information, on the address and patients' names that they thought didn't have the right to remain in the UK with the Home Office. After a challenge was brought, the MOU was withdrawn, but data sharing continues through the NHS charging programme, where those migrants who have debts in excess of £500 can be reported to the Home Office, and we're told that a new MOU is being drafted. So there are continuous iterations that practically impede a migrant's rights to public services and effectively make hospitals a place of immigration enforcement. So whilst the Coronavirus Act now makes access to testing and treatment free, and so it should be available for all, the fact that the charging program enables the NHS to share data means that there is a practical barrier to a significant population of people from accessing necessary care and necessary treatment, treatment and testing that would protect all of us. Now, one of the two particular components of the hostile environment that we'll be looking at is the NRPF no recourse to public funds, a particularly powerful component of the hostile environment. What it is a condition that denies those who are on grants of limited leave to enter or remain access to certain defined public funds. So these are not irregular migrants. These are those who are regularized with leave and who have a condition slapped on that grant of leave, permitting access to social housing, income-based job seekers allowance, carers allowance, and so on, and support that's tied to those benefits, such as free school meals. And it goes further to criminalize those who access those public funds. The power to impose the NRPF has again been something that has been expanded or escalated. So Section 3 of the 71 Act gave the Home Office discretionary power to impose conditions where there is limited leave. Among those imposable conditions, 3C2 requires the individual to maintain and accommodate themselves and any dependents without recourse to public funds. But that discretionary power from 2012, the inception of the hostile environment, began automatically to be applied to almost everyone granted limited leave to enter or remain. Going still further, the automation of that NRPF condition is now set out in primary legislation. So 117B3, which many of us practitioners will be very familiar with, now makes that automation, now puts it into primary legislation, into law. The obvious implication of not having access to this support is that without social security, those on NRPF conditions don't have a safety net to fall back on. There's a higher risk of destitution, of exploitation, of abuse, all of which are particularly felt now where unemployment and insecurity are rife during the pandemic. So crucially for the case, the most recent case on NRPF, the two exceptions to when an NRPF condition may be imposed or when it may be lifted are laid out in 1.11a of Appendix FM. And they are, firstly, that the applicant is destitute, so is already suffering some sort of harm, or that there are particularly compelling reasons relating to the welfare of a child in receipt of very low income. So they require that there is some harm or some compelling reason already to be felt in order for an application to be made for the NRPF condition to be lifted by the Home Office, and then for them to be able to access parts of the social welfare system. There has been a policy, a guidance that was put out, which has amended NRPF slightly, and I don't think that's an understatement of the remit of the guidance. It came out on the 23rd of April 2020, so already 1 month into lockdown when several people with leave in the UK were already being laid off, didn't have access to income, and so on. And they include, quite comically, access to coronavirus testing and treatment, somewhat repetitious because of course the coronavirus bill, which became an act in end of March 2020, already made that possible, but access to some limited relief. So the coronavirus job retention scheme, the coronavirus self-employment scheme. But now, if one of your clients is here with leave and has the NRPF condition stamped on it, and they are not furloughed, so they can't avail of the job retention scheme, they are instead, say, laid off, or they're self-employed but fall below or don't fall within the cap on self-employed relief, or don't have the number of years of returns necessary to get that relief that is being provided, they will not be able to access universal credit or any of the supports that we laid out previously. What is NRPF? So this is a still from last week's Parliamentary Liaison Committee where Boris Johnson gave evidence, and this was the still capturing his response to Labour MP Stephen Timms, who explained the circumstance of one of his constituents, a couple on limited leave in the UK with an NRPF condition facing imminent destitution. And when asked what he was to advise his constituents, Boris Johnson said, well, hang on, Stephen Timms, why aren't they eligible for universal credit? So not knowing that people are forced to work for less than minimum wage at maximum risk in the informal economy because of this NRPF condition. So there have been 3 significant challenges to the NRPF, and all of these are live links to the cases. So the first one was 6 years ago, the case of Fake, a JR in the UT, where the claimant argued that the introduction of the policy was procedurally flawed. It brought in the test for those exceptions through guidance and not through the immigration rules. The case was successful. However, the Home Office simply reintroduced the NRPF policy in the correct manner in how we now have it as an amendment to Appendix FM of the immigration rules. Learning from that, a second challenge was brought last year in 2019, case of M&A, on the substantive legality of the policy, specifically arguing that it breached Section 149 of the Equality Act. And that was due to be heard last year, but ultimately conceded, with the Home Office accepting that the policy should be reviewed in compliance with the Equality Act, public sector equality duty, and compensation was offered to the claimants. An interesting and important read, though, is a response to the review, which was a report published by the Unity Project, again, that's a live link, in June of 2019, which highlights the obviously discriminatory impact and suffering caused by the policy, all of which brings us to the most recent challenge, a case that was before the courts just 2 weeks ago, the case of W, a child. The facts are W is a British child born in 2011, so now 9 years old. He brings his claim on with the help of his mother, litigation friend Jay, national of Ghana, who first came to the UK in 2009, granted leave to remain, since then has been granted subsequent leave, all with an NRPF condition. She's also a carer for mentally disabled people. Now, she and the claimant have suffered extended and protracted periods of destitution. They've been street homeless, and in this occasion, on the last grant of leave, put in the application evidence that she was likely to become imminently destitute. So the challenge was brought with Project 17, arguing that the imposition of an NRPF condition where destitution was imminent was discriminatory and incompatible with Article 3, because it effectively forces a migrant with lawful leave into precarity, into destitution, before they can apply to have the condition lifted. The court agreed to a limited extent. So Lord Justice Bean and Mr. Justice Chamberlain on the 21st of May 2020 held that the NRPF policy as it currently stands is unlawful under Article 3, to the limited extent that Gen 1.11a, the extracts of which we looked at a few slides ago, and the instruction don't adequately recognise, reflect, or give effect to the Secretary of State's obligation not to impose the condition of NRPF in the cases where the applicant is not yet, but will imminently suffer inhuman or degrading treatment without recourse to public funds. So it is some movement in the hostile environment policy and a triumph, no doubt, but it really is only protecting regular migrants with who are on the brink of facing destitution. And now I will hand over to Bronwen, who will take us through the second pillar that we're looking at in the hostile environment policy, which also considers destitution.
Thanks, Sangeetha. So this is all going to culminate, this part of the presentation, in the recent case of Zenecu Ligason, which came out, it was hot off the press, it came out within the last month, it isn't reported yet. But I'll start with, as indeed that judgment does, an examination of the framework of the current fee waiver policy. And I do hope that you've all got video of me, because I don't seem to have video of myself, but yes, that's fine. Okay, so the current fee waiver policy, the current version dates from January last year. It is still in force despite the judgment which found it to be unlawful, because that judgment has been stayed pending appeal. It's still live on the Home Office website. It provides that there should be exemptions, so there should be waivers for the fees for application forms in 3 circumstances: where the applicant is destitute, where paying the fee would cause the applicant, the applicant to become destitute, and where there are exceptional circumstances. It does not say, and this is important, it does not say that this is all under the framework of whether or not an applicant can afford the fees. It actually doesn't say what is the overarching consideration at all. It just says there are these 3 categories. There is reference in the introduction to the policy about a decision maker having regard to whether the applicant can afford the fees, but essentially it seems to say that eligibility is limited to 3 circumstances: destitution, imminent destitution, well, destitution would be caused by paying the fee, and exceptional circumstances. And the 3rd category of exceptional circumstances is particularly poorly explained. It's set out in 2 places, page 16 and page 21 of the policy. At page 16, it seems to be that exceptional circumstances constitutes being destitute, or the application fee would cause you to become destitute. So it's just a reiteration of the first 2 categories. At page 21, it doesn't really elucidate it much further. It says if in relation to their income, they incur significant additional expenditure to provide for a child's well-being needs, as one example. They don't give any other examples, that's the only one. And then in discussing the well-being needs of this child, there is reference made to outlays for illness and for special needs. So we're looking at a poorly child, a child who has particular needs that require particular financial outlays beyond what you would expect just from caring for a child. So that's the current version. And on the next slide, we'll just look at a quick overview of the case. Thanks, Sangeetha. So this is Zenecu Ligason. It's not reported yet, so we just have the JR number. And the facts were that it was a family of 5 Ghanaian nationals. So there were the parents who had both overstayed working holiday maker visas in the past, and 3 children, 9-year-old twin boys, and I believe a 5-year-old girl, who were all born in the UK. Obviously, because of their immigration status, the mum and dad have no right to work, no recourse to public funds. So they don't have any way to earn money or have money from the benefit system. So they are accommodated and supported by friends. They're provided with accommodation by friends. They're provided with some money towards living expenses by friends. They also make use of food banks on occasion, or a particular food bank, I believe. And their lawyers indeed were acting pro bono at the time they made their application, and I imagine right through to this judgment. So they're not destitute because their accommodation and their living needs are met for. And anybody who's familiar with the NAS system will know that you are not going to be provided with asylum seeker accommodation, for example, if your accommodation needs are provided for and you have money to live on. Those are the 2 planks. So if you don't have accommodation, you'll get accommodation provided and your living needs met if those are not the case. So they're not destitute. However, obviously, if they're getting maybe 20 quid, 50, who knows, however much a week or a month from friends, there is absolutely no way they're going to raise £7,665 for 4 applications and 5 applications and 5 NHS surcharges. So they made their human rights claim. The judgment goes through in detail their claim form and their application for a fee waiver. They were obviously very well represented. They checked all the right boxes. And what they selected is they said they didn't tick, we are destitute. they ticked, we will be destitute if we're forced to pay this fee, which actually isn't technically true because they were never going to be able to pay the fee, so it simply doesn't arise. And they ticked, we have other exceptional circumstances. And the cover letter set out what their financial provision was. There were bank statements attached, statements from friends, all of this evidence. Now, the refusal letter refused the fee waiver on the grounds that they were not destitute, not expected to be destitute, and there were no exceptional circumstances. And it went further than that. It advised that they hadn't made a human rights application because they hadn't paid the fee. So they were therefore liable to removal and to exposure to the hostile environment, which of course Sangeetha has laid out the framework for that. And on the next slide, we'll see direct from the refusal letter what they were told. You can be detained, you can be prosecuted, fined, and imprisoned. You can be removed, you can be banned, you're not allowed to work. Well, they knew that already. You're not allowed to rent a home, you can't claim any benefits, you can be charged by the NHS, you can be denied access to a bank account, the DVLA can prevent you from driving. All of this, of course, they'd be well aware, but there it was in the refusal letter. So it's quite clear, you have no recourse. So what is the problem with this decision? Well, we'll look back a bit at the history of the fee waiver policy. It began with Osman Omar in 2012. This was a claimant who was resisting deportation. And as is usual in the case when you resist deportation on human rights grounds, you're granted 6 months to leave. And because of a problem with his identity documents, probably don't have time to go into, it was granted in the wrong ID. So by the time that was all worked out, his 6 months had almost expired. And then he presumably only get another 6 months. So he argued that he wasn't able to pay the fee. Now, he was destitute. He was in receipt of NAS support. All of that time, he remained in receipt of NAS support because he hadn't got his documents to have his leave to remain. So he had been assessed as destitute, but his argument was he couldn't pay it. And therefore, the fee was a barrier to making the application, a barrier to accessing his human rights, essentially, and therefore unlawful. Home Office refused to grant the waiver, and the position at that time, she said, I think probably Theresa May then, she was unable to do so under the relevant regulations, which was not correct. The relevant regulations provided for a waiver. So the refusal and the lack of provision for a waiver were found to be ultra vires, a predecessor provision to the current provision that provides for the fee waiver. And the court found that fee waivers must be granted where imposing a fee would be incompatible with convention rights. So what does that mean? When is it incompatible? And so we've got these tests that have sort of been labeled destitution and affordability, but destitution also has exceptional circumstances. So the first one is destitution. The 2013 policy that came out as a result of Osman Omar confined the exemption to facts mirroring that case. So this is what they like to do. They get a judgment, they don't like it. And so they define the policy that comes out as narrowly as possible. And they say, all right, you don't have to pay the fee if you're destitute. And that's what the refusal letter in Zeneku-Ligason reflects. Are they destitute? And indeed, the 2019 policy that the refusal letter was based on also focuses on destitution and never explicitly says that, in fact, the test is affordability. Well, based on Osman Omar, what's the problem? The problem is a further case, and the case is Carter. And that came out in 2014. I'm sorry, I haven't provided the full case reference. We'll do that in a follow-up. But the facts of Carter was he lived with his grandmother, who gave him £20 a week. He'd been in the country since he was a child. So he wasn't destitute. And he said, nonetheless, the fee waiver policy should apply to him because I can't pay it, I can't afford it. And the court agreed with him. The key question is, can he get his hands on the application fee? If not, there's a barrier, and that means it's incompatible with human rights. Now, the Secretary of State's argument in that case was that it's not a breach of human rights because the Home Office has a residual discretion to grant leave even if a proper application hasn't been made. That was rejected on the basis that it would leave the claimant in an administrative grey hole, I think was the term used in the judgment, but we could say black hole. It leaves him in the hostile environment. It leaves him in limbo until this discretion, this, noblesse oblige discretion is granted. So Secretary of State got permission to appeal to the Court of Appeal, but they didn't pursue it. So Carter remains. It's a high court case, I believe. And the Home Office's position, their concession in Zineku-Ligason, one of their concessions, are that this is right, Carter is right, Carter was correctly decided, the test is affordability, and those who would be destitute form a subset of those who cannot afford the fee. They argued in Zineku-Ligason, unsuccessfully, that the January 2019 fee waiver policy reflects this position. So this side issue, but not side issue because it is intertwined, arose in Zineku-Ligason, which is this line of cases that have suggested, that have established, in fact, that to make a human rights claim, you don't need a formal application, you don't need a fee, and that is really confusing matters. And here they are. There's Asan from 2017, which established that no, a human rights application has to be considered because it's a human rights claim. And even if it's not on the right format, it's not in the application form, no matter when it's made, it doesn't matter, the Home Office has to consider it. Shrestha, however, in 2018, modified that and said you can't say that if it's raised in a Section 120 notice, that's a human rights claim. So that's an interesting subset point. Then there's Balajigari, one of these tax cases, that says that a human rights claim could, for example, even be raised in a covering letter to another application. And then finally, pulling in the opposite direction is MY Pakistan, which says that actually the Secretary of State can require fees and forms in human rights cases, and they can ignore claims made in the wrong format. But that was arguably obiter dicta, because in that case, the Secretary of State conceded that a human rights claim had been made. That was also one of these domestic violence cases where the argument was over whether this domestic violence claim necessarily raised a human rights claim. And that's been a battle going back and forth in the courts that we don't have scope for here. So we'll put MY Pakistan to one side. Judge Blundell in Zineku-Ligason thought that his decision was not contrary to MY Pakistan, and I can't really take much further than that. I think it might have been a bit fudged, to be honest, but anyways. The Home Office's position and the concession in Zineku-Ligason was that this line of cases is correct, there's no fee necessary, and therefore, they said, there's no fee waiver necessary because it doesn't have to pay a fee in the first place, his family. But went further than that and said, if there's no fee paid, then I should be entitled to prioritize claims that have been made properly with the proper fee and form. So circling back to Zineku-Ligason, here is a summary of what was decided. First of all, what's the test for the fee waiver? The refusal letter, of course, it doesn't explicitly say it, but reading it, you very much get the impression it's set out in full in the judgment. The test is destitution. Destitution will be caused by the fee or exceptional circumstances. The claimant said, this is wrong. You've looked at whether we're destitute. The test is affordability. The Home Office conceded this. Yes, we agree. And therefore no decision necessary by the upper tribunal, so to say this concession has been made and correctly made. Did the decision rely on the policy? I think everybody agreed, yes, it did. But the next question, of course, is it lawful? So I've mixed up these two categories a bit, but you can see essentially the argument for the Home Office was this policy is arguable. That's the Home Office position at the JR. It is lawful because it's consistent with Carter, whereas really the position reflected in the refusal letter, if you go back to the first column there, is that they were applying, they were quite clearly applying a destitution test. And the court indeed said, yeah, that you're not getting anywhere with that. It's quite clear that this refusal letter is applying a destitution test and the policy is unlawful. The next question is, even on the facts of the case, if the policy had been lawful, would it have been lawfully applied? The position in the refusal letter was that the evidence the claimants had put in was insufficient to show destitution. Well, that's not the test. So the claimant's position was, first of all, the test is not destitution. But second of all, our evidence is clear and sufficient to show that we can't afford the fee. The respondent's position was actually no, we reached a lawful decision on lawful policy applying the affordability test, that the evidence was not sufficient to show it was met. And the court said no, looking at this evidence, you can't possibly think, no rational decision maker could possibly think that these people could afford this fee. Even if it did apply, it wasn't rationally applied. So this decision is unlawful. So then this side issue, not really side issue, is it an answer to the unlawfulness of the policy to say, well, never mind, the claimants didn't need to pay a fee at all, just put in a letter. You don't need to make an application. That was not a position set out in the refusal letter. We've seen the position in the refusal letter. You are not destitute. You do not get a fee waiver. You have not made a human rights claim. You are liable to be removed. You are liable to be subject to the hostile environment. That was the position in the refusal letter. So the claimant's position was, when this novel argument was raised by the Home Office at the judicial review, no, these cases are not an answer. And that's not what you said in your refusal letter in any event. And that the fact that the refusal letter says what it says shows that these cases are not an answer. And the Home Office's position, as I've set out, take it slightly out of order because this was a new argument for the Home Office raised in the judicial review. They said, you know, that's all very well. So there we go. We can just wave them through, and we have discretion to consider the human rights claim. And you may think that this is an echo of something else. Judge Blundell also thought this was an echo of something else. He thought this was an echo of the argument in Carter, that it's the argument in Carter being that you don't, no, sorry, it was Osman Omar. You don't need to have a fee waiver because there's a discretion to grant a human rights claim. And Judge Blundell came to the same conclusion that no, this is not acceptable. It's not compliant with human rights. It's particularly not compliant with Section 55 of the 2009 Act, because it confines this family, including 3 children, to a half world of irregular immigration status until such a time as the Home Office sees fit to get around to their application. So that was the outcome of that decision. So where are we now? Well, it's not reported yet. It's not effective yet because the Secretary of State has obtained permission to appeal to the Court of Appeal. The decision is stayed. To be honest, my perspective, I think that must be right because we seem to have a little bit of a muddy mess in terms of the case law in this area, and quite what the situation is where form is not done, a fee is not done. So the fee waiver guidance remains in force. But remember, there is Carter in any event. Carter is the case on which this case was won. The test is affordability, and the Home Office have conceded that. That's not going to be an issue at the appeal. And this case has established, which I think the Home Office can't possibly contest, that a holistic view has to be taken of the evidence that's submitted. Obviously, you want to submit the very best evidence that you can with the application, but that being the case, if there are boxes the Home Office thinks should be ticked that haven't been, they should take a holistic view and say, can this person or can this family or can these people really afford to pay these fees? So that's it on fee waiver in Zenecu Ligason. Thank you for joining us for our webinar. I think we have Sangeetha back again. You have our contact details there to follow up with any questions after the fact. The materials should be sent out. And in the meantime, shall we have a look at what questions we have?
Yes, so apologies for any inelegant use of technology. We're just trying to go through this. I can see firstly there are a couple of questions in the chat asking to send the slides and notes. Yes, of course. So again, the slides will all be sent out to anyone who's registered. There is a question from Bulawaji Ikumaoi saying that they have a client, a child with severe sickle cell condition. She has NRPF on her BRP. Her guardian works for the NHS. She's ready to retire next month. How can I get the NRPF off her BRP? So again, as we went through on the NRPF test, the test is imminent destitution. So that is quite clear in the NRPF test, and far clearer than the fee waiver policy in the line of case law that's emerged in that. There is an application to go through. There is no public funding for that application, and it is a fairly complicated application, but we can send the link to that along with the slides. Bronwen, I don't know if you've gone through the question.
I'm going to plead technological difficulty. If there are any relating to me, can you read them out and I'll answer?
We've got Jerry.
Yes, Jerry asked about the Windrush generation. I did manage to see that one while you were speaking. So I think the question there was if the Home Office accepted that they were here, would they not have been eligible for leave to remain under the 20-year limited leave to remain? I think my off-the-cuff answer, subject to anything Sangeetha has said, and please chime in, Sangeetha, is that yes, they would, but probably the same difficulties arise in relation to documenting those 20 years in the UK, firstly. And secondly, really, they were entitled to ILR, so why should they settle for limited leave that has to be renewed, I think would be my answer.
We've got another question in the chat which says, there is an issue which is silent. If the no recourse is lifted, the guidance says you'll go back to 10-year route. Is this correct? So the no recourse to funds condition is just a condition. So that doesn't take you on or off a track. So yes, that is correct. I think that those are all the questions that we have that don't relate to slides. Apologies if I've missed any, again, inelegant technological use. The slides will be sent to all participants. They'll be uploaded on our website. The recording of this will go live onto the website on Monday, or by Monday rather. And thank you all for signing in. Apologies that we slightly overran. Keep a watch on the hostile environment, specifically this week that the government are in discussions with the EU about trying to lift family reunion for unaccompanied children. So there are different ways in which this policy is coming into play, so keep an eye out. And any questions, feel free to email us. There is also, I can see, a poll that has gone up. Please feel free to answer this if you can. That would help us. And any suggestions for further topics, just email us.